Hi guys, it's Kathy. I hope you're doing well. So yesterday we were talking about wearing a shirt that matches the green screen. This is not the color of this shirt even a little bit. Nope, nope, nope. It takes all the yellow out of everything. Hi Facebook. Watch, 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 watch. This is still not the color of this shirt. That one's not bad. That one's fine. That's what we'll land on. Hi Maria. Yeah, so I can't wear anything green. I can't wear anything green here because that's what happens. But anyway, we're not here for my shirt. We're here for Crazy Karen. Let's go to Crazy Karen.
With a 5-point harness, correct. And is it forward facing or backward facing?
Forward facing.
Okay. All right.
Your Honor,
Yeah.
he's saying that the car seat that they've been, the one that they were exchanging, he's now outgrown that car seat.
He has. Okay. So that car seat goes to 35 pounds. Your 9-month-old is
It goes to
35.
30 pounds.
Your 9-month-old is 30
He's
pounds.
27 pounds.
Okay, so it's not outgrown, right? Okay. All right.
Yeah.
Okay. Okay. So we're not going to use that car seat anymore? Okay, Dad can still use it, right? For 3 more pounds, right?
Yeah, but then after that, what's gonna happen?
What do you think?
I mean, he should get his own.
You think he's
car
not
seat.
going to?
I don't know.
Okay, Dad, I'm ordering you to get a car seat that complies with Nevada law for a child that's over 30 pounds.
I'll follow that.
All right? Those type of car seats are not the magnificent infant carrier seat. So you guys are going to have to exchange your baby. And I don't like that, okay? Because you think he's starving your baby, right? If I thought somebody was starving my baby, I wouldn't want to be breathing their air, right? So I'm surprised and shocked that you want to be there for the exchange at 6 a.m. when you leave the house at 7:30, right? That's crazy to me, okay? It concerns me a little bit, okay? So let's be careful when we exchange that baby and we hand that baby to each other. I don't want to see what I saw in that video, okay? Let's be kind and appropriate. Anything else that I need to deal with that changes anything about that?
In terms of the schedule of exchanges.
Yeah. Does that anticipate any issues? Council, do you have any other concerns about that exchange? Is there anything that you see might be an issue that we should discuss?
No.
Okay. Does Mom have any concerns about it that we can
About the exchange,
could preemptively strike if
I believe so.
we can deal with? Okay.
Can we change the location of the exchange? Can we meet at the police station, like the headquarters of Metro?
No. Here's why. They don't want Julian, and I know he's 9 months. There's this sense that that's a safe place. It's not. Guess who's not at Metro headquarters? People who respond to incidents like this. Like, they're not coming running out, okay? It's detectives and civilian workers. It's not the safest of places. Also, I'm real concerned about an overexposure to police for young children. Here's why. Adults should be able to deal with their problems, okay, in a way that's civil. You can disagree about stuff all day long, but we shouldn't need the police to be there. I don't want Julian to grow up, and I know he's 9 months old, to grow up thinking that it's appropriate every time 2 adults disagree that we got to call the cops, or that Mom and Dad are so dangerous that the only place they can be together is at the police station, okay? So I know that a lot of other judges do it. I've never ordered it. I've accepted a stipulation about it. It's not the safest place for an exchange. It concerns me. So that's why I'm saying no at this point. I don't want you to be on a trajectory where we're having exchanges because I think you're both so dangerous at the police station. It's not conducive for a young person. We haven't had any problems while we've had those exchanges at your homes. if you want to stipulate or agree to another place, I'm happy for you to do that. But at this point, I think it's appropriate. Anything else?
Just on the custody and exchange, issue, the schedule and the exchange. There are other things that we asked for. so
I know. So I want to make
Okay.
sure that we've dealt with every issue that we can think of about this exchange. All right.
I
Okay.
think we covered that.
All right. Council, I am going to order that mom go to infant class. At this point, I don't know at 9 months if the infant class is the best class. Joe, can I see the list of Clark County parenting classes? Council, I'm going to deny your request for a psychological evaluation. I know this is the second time you've raised it. I think council argues that there haven't been abrupt mental and behavioral changes, that perhaps undergoing a psychological evaluation would have taken the wind out of your sails, so to speak, and taken that argument away from you. And certainly the court has made no secret of my questioning of some parenting decisions and communication issues. I am going to order that within 48 hours, each parent respond to any message on Talking Parents. It is going to be important that we do that because we have to exchange information, okay? We have to. We've got to do that, especially now with this decision. And I think I told you before, I don't expect you to talk in a way that perhaps, I don't think, and it's important that you listen. I don't think that it's, important that you speak to each other in the manner and way that you spoke to each other in the past. How was your day? That's a nice shirt. What do you want to eat for dinner? That's communication. What you two have to have is not communication. You have to have the sharing of information. Okay? So, just like when I read a police report and the police report said the red car ran the red light and hit the blue car. Those are all facts, actual things, observations, and they're in the moment. Okay? So when you speak to each other, remember those guidelines. You are sharing information to the extent that you need to get the job done. Okay? That means Carol and I share information to the extent we need to in a civil and professional way to get the job done. I don't ask her about her weekend. I might, but it doesn't. That's not a professional relationship I need you guys to have. You are in the business of raising Julian and making sure Julian's successful. That's your goal of your corporation. Get it? You guys are the only two partners. You got to work together to make that happen. So if Julian has a fever, because you think maybe he's getting a new tooth, maybe not, let me watch him. I gave him some Motrin. Then on Talking Parents, I expect to see. Julian had a low fever. It was 99.5. I think he might be teething, okay, because he seems to be chewing on his favorite whatever. But I'm not sure. I gave him Motrin, the recommended dose on the bottle, at 5 p.m. That is the exchange of information necessary. Okay, so that when Dad gets him and he's slobbering and he's putting everything in his mouth, Dad can make sure and have the ice chewer or what things that for teething, and make sure that he has his favorite thing for teething, and not give him a double dose of Motrin. You guys don't want that to happen, do you? No. You got to share that information so that Dad can see it and say, okay. And then Dad, when you give him another dose of Motrin or it seems to have subsided, you tell Mom, you know, the fever went down. I checked him again. It's 98. He seems to be chewing on some stuff, but no fever. I didn't give him any Motrin. This is information for a 9-month-old we have to exchange. All right? Food and food allergies are important at this time and can show up in eczema. Sure, right? So when you introduce a new food, you have to only introduce one new food at a time. That's what the pediatrician told you, right? For a certain number of days, 3 to 4 days. So if you introduce a new food, gotta tell each other, right? The doctor told you you can't give raw honey. You can't give certain things. You can't give this. You can't give that, right? You have to work under those rules, okay? Mom, if you get information, you can't hoard it, okay? Why? It's not good for the success of your business of Julian. You got to share that information. So if the doctor tells you you cannot give this kind of formula, you got to tell him, okay? To the extent that mom is going to supply breast milk, dad, that milk, if it's supplied to you at the exchange, that will be utilized first, okay? Before any formula supplement is utilized. Do you understand what I'm saying?
Is she going to provide it?
If she does,
Okay.
okay? If she's able, if she wants to, if all those things, the ball's in her court, if she does that, then you will supplement. Because we do not know what formula the pediatrician is requesting, Dad, next time you have the baby, you need to take the baby to the pediatrician.
I need to know his or her name.
What's the name of the pediatrician? We didn't know this last time we were here.
Any Southwest Medical. I mean,
No, that's not what we're doing. What is your baby's pediatrician's name?
right now he's just last seen Vera, Dr. Vera on Flamingo at Southwest Medical.
At Southwest Medical? Who was the pediatrician when the baby was born? Who was your pediatrician that you picked?
Southwest Medical. His insurance sends him to Southwest Medical, and he can go to anyone. They transfer records. They all have one database. It's one big company with different offices. So as long as you call and make an appointment, you can see the pediatrician. They're gonna have all the records.
What insurance do you have?
He has children's health insurance in Nevada.
Is that Medicaid?
Yep.
Sir, what were you going to say?
I have a pediatrician that I'd like to visit, close to my apartment.
Okay, is it a group? What's the name of the pediatrician?
I don't know the name right now.
Okay, so here's the thing. Most pediatric groups take Medicaid. Some don't. If you choose to take the baby it seems as though not assigned to a specific pediatrician, but to Southwest Medical, which is not a pediatric office, but has regular doctors.
They have
But they do it all, right? They have a pediatrician, but they also have, if you were sick, you could go to Southwest Medical. Correct?
Yeah.
Okay. If you want the baby to see one pediatrician at a location that's close to your house, I'm going to allow you to do that, okay? Pursue it because he doesn't have. You need to give mom notice in writing of that person's name, the pediatric group. If there's a cost associated with that's higher than what it would be, do you pay anything for a copay? You pay zero copay at Southwest Medical. You will be 100% responsible for that copay, okay? Or if you're just going to pay cash or pay whatever it is. I'm going to allow you to go there and follow their recommendations about formula supplements, about an eating schedule that's appropriate for a 9-month-old, and what types of foods the doctor would like the baby to eat, and in what schedule and in what fashion. Many times they say we're going to start with greens, things only colored green, because they're much easily digested, and we only introduce one new thing every 3 days, and we keep a chart and a schedule. Okay? That isn't what Southwest Medical told you. We started with stage 2 instead of stage 1. They didn't give you a schedule about introducing things, and they didn't give you a schedule about the color or how things are digested. That concerns me a bit. There's 2 parenting classes, a baby care class that I know Dad went for children ages birth through 6 months, and triple P positive parenting is for 2 to 11 year olds, and that's for difficult. I'm going to send mom to nurturing parents and families. That's for 6 sessions for parents of children ages 6 months through 4 years. It promotes positive, healthy, nurturing interactions with infants, toddlers, preschoolers, stress management, how to establish routines and handle anger, problem solving techniques, and positive management methods. All right.
You know, I request that Dad also take that class for 6
Mom,
months.
Dad took baby
He
care.
took through the 6 months, so we'd like him to take the 6 months and older class as well.
So, do you want Mom to take the baby care class too then? That's not what I'm doing.
The baby's 9 months, so,
Right.
I mean, if they can both take the same class.
No, that's my order.
Or the class that, is appropriate for his age.
Okay, that's my order. We coming up to evidentiary hearing. I expect that you communicate on talking parents. You understand that that's one of the 12 things that I have to look at is whether or not you can cooperate to meet the needs of the child. Okay, I need to know that. Okay, right now I'm not seeing that. Okay, so I need to know that you're on talking parents, that you're checking in, that we're doing that. I'd be real interested in counsel and seeing medical records, okay, from those well checks, from birth on. Those would be real important to me. So important, counsel. I'd subpoena Southwest Medical right now, and whatever place Dad selects, because I want to know. I want to know who at Southwest Medical said continue on co-sleeping, and about the feeding and those things. It's
No
really
one.
concerning to me. Mom, the hoarding of information could seem as though an exercise of power and control or gatekeeping. I want you to be real careful with that as you go forward. I'm going to remember that I've talked to you about that a couple of times, and the issue of makeup visitation is appropriately addressed at evidentiary hearing. Counsel, anything else?
Yeah, we'd like to address the child support.
Go ahead, counsel.
So, Dad stated, it's in our motion, that his monthly income was about $1,800.
Right, and
I
you just think
believe.
that that's not true, and so you want him
Correct.
to file a new one?
Correct. I don't believe that's true. Either he's not playing poker at enough hours, or maybe he's not as good of a poker player as he may think, or he's not disclosing how much he's making. So I'd like to see some kind of records. That
You asked for
that
a
show.
profit and loss. Counsel,
Right.
have you subpoenaed the appropriate records from casinos regarding his?
No, but the casinos don't keep track of how much you make playing poker.
Okay, so we're gonna rely on Dad, and we're not gonna.
Well, I'd like to see some kind of record. I mean, we'd have to do that in Discovery, but I don't know if that
Well,
keeps a
Discovery's
record.
getting ready to close because you got a counter call on March 7th. So some of this stuff, I can tell you all have a duty to keep that financial disclosure form current with me. Certainly, we're, I'm not going to see.
It doesn't make sense if he says his expenses are $5,000.
I understand. Okay, and that's an argument you can make. But I'm going to encourage everybody then to get the appropriate records before Discovery closes that you want to get. If they don't exist, they don't exist. I can order you, counsel, to update your financial disclosure form and make sure that it's current with the court and that's an accurate reflection of those things. Certainly,
We do that before calendar call.
the parties could exchange tax returns or tax documents. The parties could exchange other things. Those are all a function of Discovery. And certainly counsel can argue that, $1,800 a month and with your expenses at $4,900 a month doesn't make sense. And that I should impute income. That argument is for evidentiary hearing. And so we'll get there.
We had asked right now for, at least until the evidentiary hearing, the child support abatement. I mean, again, that stemmed from us asking for temporary sole physical custody, which we're now doing temporary joint physical custody. I still think under the circumstances it might be appropriate, but it certainly doesn't need to be adjusted. It should either go away or stay at the current level. So I think those are the two options until we get to evidentiary hearing.
Counsel?
Mom's working 21 hours as a waitress. Dad's claiming that his expenses are $5,000. I would say that his income greatly outweighs mom's.
Well, no, I looked at it, and mom's making $1,479. That's pursuant to her FDF she filed on January 17, 2019. Dad's making $1,856. They have joint physical custody. If I
Right.
do the calculation, that means 18% of mom's is $266.22, and 18% of dad's is $334.08. If I take the difference, it's $67.86. That'll be the amount that dad pays to mom until
That-
further
that-
order of the court.
That's believing that he's making that amount, which any reasonable person would not be able to believe that based on his expenses.
Counsel, I have to take the numbers that have been provided to me. If you believe he's lying, or he's fibbing, or he's padding this, then we'll certainly hear about it at the evidentiary hearing, and I'll take a look at the records, and I'll make a determination. And if he is lying, certainly I can reallocate and go back in time and change everything, reduce it to judgment immediately. So that's the order that I'm making. That's the statutory calculation that's required. I do need an order from today. Council, you'll prepare the order. Council, you'll sign off. I'll see everybody back for calendar call on March 7th.
I apologize, Your Honor. One question did occur to me.
Yes.
Which is the upcoming weekend. I don't think we decided. My proposal, again, would be that that should be my client's weekend. I believe, do we schedule our visitation today? It's Wednesday today, so I would suggest that perhaps we do an exchange shortly after court at some point today. And then he has this upcoming weekend, and then there will be an exchange back to mom on Monday.
Monday morning. Council, the baby's with mom right now, and today's Wednesday.
Dad's been having the last few days, and mom's requesting that for this weekend that she be able to have this weekend. So if he is going to take him today, she's requesting that her weekend start this Friday, go through to Tuesday, and then next week he'd have Wednesday through Monday.
Okay, so today though we do need to do, today's Wednesday, and Dad's supposed to have Wednesdays and Thursdays pursuant to the new order. Is there a time where we can exchange the child? It should have been at 8 a.m. this morning, but when can we do that?
So he has Wednesdays and Thursdays at 7 a.m. So can then use the child now.
I think they were scheduled for a 1 p.m. exchange today anyway.
They were already scheduled for 1
So,
p.m., so
we're
can we
fine to
just
keep
do it
that.
at 1 p.m.,
1
Council?
p.m. today.
That's what was already scheduled today?
Right.
Monday.
So to be on an overnight.
Yes. He's in that till Friday morning at 7:30.
It can't start on Monday, like next week, because of the visitations.
No, he has every Wednesday, Thursday. So it's Wednesday.
So can we just go with the regular schedule and then start on Monday? Because that's the start of the schedule.
No, that's our schedule.
Oh, it starts with Wednesday. Okay, so, yeah.
Okay, yeah, one today.
Okay, 1 today, all right?
And then is the exchange on Monday as we proposed, or?
So every Wednesday and Thursday is going to be his. I just have to decide who's going to have this weekend, okay? It literally is dividing everything in half. It'll be even, okay? I know you don't like it, but this is what's kind of got to happen. I think that it's appropriate that this weekend be Dad's weekend. We'll do the exchange Monday at 8 a.m., okay? And we'll get going on that schedule, and then the next weekend will be Mom's right after that. This is down the middle split of the days. Council?
Mom's saying that because Dad has had the child during the days over the last few days, that she would like to have the weekend time that she normally spends during the day with the child. Normally during the day she's at school, so she doesn't get to spend the good quality time with the child until the weekend days. So she'd be requesting that this weekend start with her weekend on Friday.
So he's been having 21 hours or so a week of visitation since November. Before that, he had 0. And even that 20-some odd hours has been routinely interfered with and denied. So I don't think that the fact that he actually exercised visitation pursuant to the previous parenting plan the last 2 days has any relevance. I think this weekend needs to be his. There's some connection work that needs to go on here.
And he'll have that for the next 2 days.
Okay, so this is gonna be Dad's weekend, as I ordered. Monday will be the pickup. Okay. All right. Thank you. Good luck.
Thank you.
This is the matter of Ravella versus Sangalaza, D185724822C. The parties are present. Counsel, your appearances for the record.
Good morning, Your Honor. Sean Lytle, 11640, on behalf of Nicholas Ravella, who's present.
Good morning. Everybody have a seat. We were just here on Wednesday. Let me give a procedural history since Wednesday. And then I'm going to ask, before we get into any of the substantive issues, if anyone has any objections to moving forward today. We were here on Wednesday. At that time, I made amendment to the visitation order. There was already scheduled, pursuant to my previous order, a 1:00 p.m. exchange of the child scheduled. That evening, Mr. Lytle wrote a letter to the court copying counsel for the defendant that the exchange did not happen on Wednesday.
Your Honor, I have an objection. I never received anything. I never received any letter or anything like that whatsoever.
Okay.
And I also object to being here today because I never received notice of this hearing either.
Okay. I'm going to go over the procedural history briefly, and then I'm going to allow anybody to make objections that they need to make,
Absolutely.
okay? So let me make sure everybody's on the same page about what's happened since Wednesday, okay? And then you can tell me what you need to tell me. On Wednesday, Mr. Lytle sent the letter to the court and to counsel for the defendant, indicating that the exchange did not happen, that the police were called. On Thursday morning, counsel filed a motion for a pickup order, served the same on counsel for the defendant. On the same day, counsel for the defendant at 11:58 filed a notice of withdrawal as attorney.
Her and Kimberly Hurd share a room right there.
Later, I granted the motion and granted the order shortening time. I didn't grant the motion. I granted the order shortening time and set the motion. I'm going to tell you the exact time. At 12:32 on January 31st is when the clerk's office created that hearing. At 1:28, the defendant filed an affidavit requesting the recusal of the court. The rule requires that affidavit seeking disqualification happened 3 days before the next hearing. So I know a lot has happened in the last 3 days. So tell me what your objections are, what your request is, before we even get into what's going on about the administrative procedural process at this point. Go ahead, Mandy.
Yes, so my first objection is for us even being here today, less than 24 hours notice. Less than 24 hours, there was already a court date for today. I didn't receive any notice whatsoever. I also object to the claim that a letter was sent to my attorney, my prior attorney, because I spoke with him as well. He didn't receive any letter or anything whatsoever. He didn't mention a letter. I didn't see any letter, nothing like that. Yeah, and I also object to, I don't understand, I need to understand how it was even possible within hours for all this to be filed and a date to be set, because I didn't get to respond to any motion. I didn't have that chance, and then I don't even have a chance to get to have an attorney to represent me here.
Okay. Anything else?
That's it.
So what's your request specifically about how we proceed?
That today be canceled and either canceled or moved to a later date so that
What later date would allow you enough time to file an opposition, get a lawyer, those things that you were concerned about?
at least a month.
1 month?
Mhm.
30 days?
At least 30 days. 30 to 60 days, I'm going to say.
30 to 60 days?
If they're here because she didn't turn the child over and the cops had to get involved, if I was this judge, I would say, okay, 1 month, 30 days, no problem. We'll reset this from 30 days from now. Dad keeps the child until then.
All right.
Bye.
Anything else you want to tell me, Mom?
No, that's it.
Counsel.
So, we're here on the motion for a pickup order. What gave rise to the motion for a pickup order was not only a violation of the orders made in court on Wednesday, but frankly, a violation of orders that were made months ago, subject to a parenting plan that has been entered into this case. That all happened before there was a withdrawal of counsel, before there was any affidavit suggesting impropriety. All of that occurred months ago, that schedule. So in terms of whether the pickup
I
order
have an objection, Your Honor.
is warranted at this
Hold on. I'm
time.
going to let him speak because he didn't interrupt you. Once he's done speaking, I'll give you another opportunity to talk, but just don't interrupt him. Go ahead.
The pickup order needs to be entered today on the basis of the fact that even before we came into court on Wednesday morning, there was an exchange scheduled at 1 o'clock. The defendant prevented that exchange from occurring. We still don't even know where the child is. There's a real safety concern there.
That was my next question.
And there is a,
So we don't know where the baby is?
no, we've had no responses from, there have been efforts by my client to get in touch with her through Talking Parent again, as we discussed on Wednesday morning, no responses to those. So the court has inherent contempt enforcement powers, even if I don't file a motion. And there was a contempt on Wednesday at 1 o'clock. You can call it a contempt of the order you entered Wednesday morning, or you can call it a contempt of the parenting agreement that she signed off on 2 months previous to that hearing. But either way, there was a clear contempt on Wednesday afternoon, and that was while she still had counsel of record. That's why before she had filed any documents suggesting that there was bias or prejudice on the court. So the court's inherent contempt powers, I think, warrant in this case that you could issue a pickup order on that basis alone. But either way, I think we need to get this child to the plaintiff today. And then what happens beyond that is subject to further orders of the court. But I think right now we have a clear contempt, and we have some serious safety concerns about the child. And I think the best way to remedy that is, again, it's a pickup order. It's temporary. It's subject to change. But I think for the short term, she can have as much time as she wants, frankly, to respond. But while she's figuring that out, I think we need to make sure that Julian is safe and sound with Mr. Ravello.
All right, so my first objection is this claim of a schedule happening months ago. I don't even know what he's talking about. You changed the schedule just 2 days ago, so for him to be referring to months ago, that doesn't even make any sense. And then on top of that too, I object to him claiming of contempt to the court because I arrived late to my house because I had to go pick up my baby from where he was with my mom, feed him, make sure he's full before he goes anywhere, and then take him home so he can be picked up. The plaintiff didn't stay. I mean, I don't know what kept him from staying there because I arrived shortly after 2:30. Yes, I know it's late, but I had to make sure my child was good and ready to go. I also had to pick him up from where he was.
An hour and a half late?
Yeah, traffic. I already live 45 minutes away from the court. That doesn't include traffic. I live way south. And then on top of that too, well, I don't know what stopped him from staying. I don't know what stopped him from even coming to pick up the baby yesterday. It's a recurring thing where he just doesn't show up without even word. I mean, look at today.
Okay, hold on. Can I ask you something then?
Yes.
Let me interrupt you so that you can respond. What counsel was speaking of is the original agreement that you entered into about visitation required a 1 o'clock pickup on Wednesday.
Right.
That was already in existence. For months and months we've always been doing a 1 o'clock pickup on Wednesday.
And we were at court.
Right. So
until
that's
after
what he
Hi,
was,
Lisa.
that was what he was talking about. So you're saying we were at court till after 12 on
Right.
Wednesday, so you couldn't get there till 1 o'clock.
I left the parking lot around 12, I'm going to say 12:20, 12:25
Okay.
for me to go pick up my baby, make sure he's fed, drive back to my house where I live far, 45 minutes
Okay,
away.
let me ask you this. It sounds like you don't have any objection then to right now an exchange today and picking up on the same schedule that was on Wednesday.
I do have an objection to that. My objection is that I provided substantial evidence to the court, and under the in the Nevada State Constitution, under Senate Bill 317, NRS 432B330, it says here that a child in need of protection, a child may be in need of protection if the person responsible for the welfare of the child fails, although the person is financially able to do so, or has been offered financial or other means to do so, to provide for the following needs of the child: food, clothing, shelter necessary for the child's health or safety. And I came to court and I provided my evidence that my child was being starved, and you asked me the question, do I really think that he's starving my baby? I've taken him to the emergency room. The doctors have confirmed that my child is hungry. He's not being fed for long periods of time. My child needs protection. I mean, it definitely needs to be a supervised visitation, because I'm not going to allow my child to go. I'm not going to neglect my child and neglect my constitutional rights, my child's constitutional rights, and let him to go and suffer when his dad is blatantly, in evidence that I proved, that I provided, writing out that he's going to starve the baby. And you overlooked it and questioned me as if, asking me if I really believe that he's going to starve my baby. I know my rights, I know my child's rights. It's stated right here in Nevada State Constitution.
Anything else?
For now, that's it.
Counsel, anything?
I just wanted to point out as a factual matter, and we attached this to the letter, which we also attached to the motion, that the contact card that the officer filled out is at 2:30 p.m. So, I mean, even by 2:30, when she said she arrived, he was still there. Officers could not find anybody there. So I don't know when she showed up. Once he spoke to the police and they told him there was essentially nothing they could do, I was done with my other hearing, and I advised him, well, just get out of there and we'll figure out what we can do. But there was no contact. I mean, this is what we talked about on Wednesday morning. If she was legitimately held up in traffic or something, I mean, that happened to my client this morning, but he texted me, right? I mean, that's what you do when you're running late. And that didn't happen here. As far as this evidence of starvation, I think the court has seen videos and pictures of this child. He's not missing any meals. He's quite big for his age. Those concerns are completely unfounded. And again, we've got here a clear contempt of a pre-existing order, not just your order from Wednesday, but your order incorporating the parenting plan 2 months prior. So I think the pickup order in this case is appropriate. Again, I don't have any faith that if we walk out of here today, I mean, she just said, I'm not going to allow him to take this child. She just told you essentially that I'm willing to do whatever it takes, including being in contempt of this court's orders, to make sure that my son is not around playing. That's what she just told you. And I think the only way to do that is for law enforcement, unfortunately, to get involved at this time.
Taser.
And then again,
Taser.
we can have a full hearing on whatever issue she wants to raise once the child is safe and sound with the plaintiff.
In conclusion, ma'am, anything else?
Yes, I do. So I object to what he said. he has the nerve to say my child is quite big for his age, as if he knows my child. So justifying that it's okay for my child to go.
Thank you, Monica.
hungry
I do
when
too.
He's with his dad. It's
Thank
okay
you,
for him
Monica.
not to
Thank
be
you.
fed. And he also just lied just now, saying that I said I don't want him to be around my child. I just want a supervised visitation. My child can see his father. I just want somebody to be able to be there at the Donna's House Center and make sure that my child is being taken care of, because my child is 9 months. And right over here, Nevada Revised Statutes number 201.090 says neglected child is defined as a child who is deprived of the necessities
Alan.
of life by his or her parents and has no means of obtaining such necessities. My child is 9 months. He can't speak for himself. As his mother, I have to be the one to observe him, take care of him, and speak for him. I mean, this is a child that we're talking about. We're not talking about a teenager who can say, okay, my dad's not buying me something, but my mom gave me some money, I can go to the store and get some food. My child doesn't have nobody to advocate for him other than me. And I just want the visitation to be supervised until the plaintiff can take a class, a necessary class, because the one that he took is for 0 to 6 months. My child is 9 months old. He doesn't know anything about feeding the baby. And he doesn't have that knowledge. Even when I tell him to feed the baby, he doesn't respond to the messages on the text message.
Exactly.
I provided this. It's just, he needs the proper knowledge in taking care of my baby. There's nobody else over there at that house who's going to be taking care of my baby or speaking up for him. So I just want that visitation to be supervised. He can see his dad, I mean, weekend mornings, I'll try to see if somebody can bring him during the week or something like that. Whenever, I just need the visitations to be supervised. Because my child is a minor, he can't speak for himself. And I really think that after we were in court here, it should have prompted you to investigate and immediately change the supervision. But instead, you changed the schedule to the 2/3 schedule, where my child would be away from his breastfeeding mother for 5 days at a time, where he breastfeeds for 5 days at a time. Right here in Nevada Revised Statutes 201.232, it says clear as day that breastfeeding a baby until 2 offers health benefits to both baby and mom, unless medically inadvisable. It also provides significant benefits to the health of the mother, including protection against breast cancer. Talks about the World Health Organization. This is in the Constitution itself. And then it says
Hi,
the social
Fozzie.
constraints of modern society weigh against the choice of breastfeeding and lead new mothers with demanding time schedules to opt for formula feeding to avoid embarrassment, social ostracism, or criminal prosecution. You can't take away my constitutional rights under the state of Nevada, under the United States, to breastfeed my child until whatever age I choose to breastfeed him. I mean, I've provided medical documents where I've taken my child to the doctor's office, and the doctors talked about a formula. I can't talk about a formula that my child is having if I don't give my child formula. I know that he's having a reaction to a formula, and yes, your opinion definitely matters about how you might know about the effect, how eczema can occur. Even if it's not a formula issue, but I've taken my child multiple times to see the doctor, provided the medical records, and it's definitely the formula that he's being given. I told Dad before visitation even started, you need to go see a pediatrician before you give the child formula, because he's only given breast milk, and he refused. I provided the text messages where he refuses, where he just doesn't even consider it, as if I didn't say anything like that.
At least 2 minutes and 36 seconds. At least.
And it takes for
That's
you
all I
to
know. I don't
tell
know.
him that he can take the baby.
I think they said they were dating for like a year before she got pregnant. And I think he left. Was it? I'm going to guess because I can't remember if it was like 1 month or 3 months after the baby was born. So I'm going to go with 2 months.
To whatever pediatrician he decides to choose. I mean, he could have done that in the first place instead of allowing my child to suffer. I gave it 3 months. I gave this visitation schedule that you did 3 months. I gave it time. He went to see his dad, but each time it's disheartening to see my child come home starving, not changed. And on the matter of not being changed too,
I didn't want to get into substantive issues, and I've given you some time, but we're way into substantive issues. We're talking about procedural things. I'm not reconsidering any decision. I'm not making a decision about custody today. What's on today is the pickup order, and I'm asking for your administrative procedural objections because there's some strange events that happened. And so I'm asking for those objections, whether we're going to go forward with that hearing today or whether I'm going to continue it. So I don't want you to waste too much of your time getting back into revisiting these visitation issues.
I'm sorry, can you say that again?
Remember at the outset when I said we were going to talk about procedural issues first. Procedural means the way things kind of happened in this case. A lot has happened in last 2 or 3 days.
Right.
And so before I even hear that motion for a pickup order, what I wanted to hear from you was your objections. You asked me for 30 to 60 more days. You indicated that you don't want to conduct an exchange now, that you're not going to conduct the exchange now.
I would prefer not to, but if I have to, if it's the order.
I'm not making those kind of orders today. I'm asking you what you want to do. You said you wanted 30 to 60 days. Anything else you want to tell me about that procedural or administrative issues?
Right. I would rather just go back to the old schedule.
Okay, so procedural or administrative issues, not about the visitation schedule. Whether we're going to have this hearing today, okay, or whether you want 30 to 60 days to respond, and how you want to work, what you want to do.
Okay. Which hearing? For what? For
The
their
motion for pickup. You requested 30 or 60 days for to it be heard on another date.
Okay, yeah, I would prefer the 30 to 60 days.
Okay, all right. In this case, is that all, or you have anything else?
Let me just.
She has a few more statutes she wants to read to you, Judge.
Oh yes, I do. In the meantime, I do want to do a paternity test to make sure that he's father, because just given the timeline, I am questioning.
So
whether-
today we're not going to bring up any other issues. If you'd like that, you could file a motion. I'm going to direct you to that yellow piece of paper. It has a lot of information, a list of resources, places you can go to get more information and requesting and putting those requests on calendar. Okay?
Mm-hmm.
Anything else? All right. This is an interesting course of events over the last 3 days. The affidavit for disqualification was filed.
Wait a second, Judge. What are you doing? The lawyer and the father just said, we don't know where the baby is. The baby is gone. We do not know where the baby is. Are you not going to find out where the baby is? I need to know.
Filed 1 hour after I set the hearing in this case. I am concerned because at the very same time, Mom's counsel withdraws from representing her. Mom indicates she didn't receive a copy of the motion. Certainly her counsel did, but she indicates he didn't. He didn't give that to her. Today she refuses to conduct the exchange as ordered. Indicates that her preference is not to do an exchange. The court is divested from jurisdiction once that affidavit seeking disqualification of judge is filed. Unfortunately, in this case, it was untimely. It was filed after this date had been scheduled. The court's extraordinarily concerned about the safety of Julian. Julian was supposed to be exchanged on Wednesday. He was not. I'm concerned. I'm worried. And I have to balance his safety concerns with the administrative and procedural rules of court. In this case, Mom's requested 30 to 60 days to respond to a motion, which is well outside of the time limits we have for responding to a motion. At most, a party has approximately 2 to 3 weeks to respond to a motion and a date set. This is difficult. I am not, all of my previous orders stand. I feel as though I cannot make an order today that the affidavit divests me of jurisdiction. I am unwilling to issue without a hearing contempt proceedings, and I'm unwilling to issue a pickup order at this time. although I'm gravely concerned about the safety of your son. And so I can't set another date for this hearing until the affidavit is ruled on by the chief judge. As I'm looking in the system, things are happening so quickly, there's not even a date for hearing for the affidavit at this point. And so I caution everybody. I'm real worried. There is an opportunity to fix this today, and we can't do that. And so we await the chief judge's order, unfortunately. Thank you.
All right.
Sleep. And so, you know what? I said, okay, we went with 6 hours, and I stayed up with the baby all night. Now, come
Hold
the
on.
morning, May 21st now, around
So I think this is the one. We've already played 24 minutes of it, but we didn't. Remember, I said I'm going to show you a little bit of this case way at the beginning. This was it. So we didn't see any of this. So we're going to go back to the beginning.
We're on the record in case D 572482, Ravello versus Sangalaza. Counsel?
Good morning, Your Honor. Sean Lytle, 11640, on behalf of Nicholas Ravello, who's present.
Okay, ma'am, state your name for the record, please.
Good morning, Your Honor.
Good morning.
Hearing Sangalaza.
Okay. All right, so this is a time set for Dad's motion for pickup order, Mom's opposition, Mom's motion to set aside order, pretrial conference, and if you would swear both the parties in for me,
Please raise
please.
your right hand, face the clerk.
You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes? Yes?
Okay, so this case was originally assigned to Department B. Parties' custody case is pending, as I understand it. There was a hearing date set when things kind of got rearranged, correct? So we need to make sure we reset that. I know there are some orders in effect. You know, there are obviously some motions filed. The motion to set aside, Mom, I just want to talk to you about that, because before I hear anything on a reconsideration request or set aside request or anything like that, it typically is sent back to the judge who entered the orders for limited purpose of just making a determination on that motion. So I need you to decide if you want that to go forward, and if you do, then I have to just remand it for that purpose. And then if she denies your motion or grants your motion or whatever happens at that point, then it would come back to me, you know, having...
Oh, oh, that's horrible. Oh, it's a new judge. Oh, that sucks, guys. I'm okay. Nothing against this judge, but I really love that other judge. I need to speak to the chief judge here because they didn't take the last judge off who needed to go off, and they did take this one off who needed to stay right where she was. Yeah, now she won't get any consequences. That judge was saving up her contempt orders. Just saving them up for that judge's decision. Oh, great. Thanks, Rebecca. But you have to find out why. Here we go.
a decision made on that motion. So before we get started, I want you to let me know what you want me to do on that.
Yes, let's move forward.
So you want me to remand it back to the judge that heard it initially for a set aside?
You're unable to look
So I've looked at it, but because it was someone else's decision, I can't then set aside their decision. I have to let that person reconsider their own decision. Does that make sense? So basically I have to send it back, or just for the limited purpose of having the previous judge hear that motion and have her make a determination. You're right, I made a mistake, I shouldn't have done that, I should set aside that order, or no, I'm going to go ahead and leave it intact, and then she'll send it back up to me, and I would then, proceed forward with whatever hearings we have to conduct, and also with the evidentiary hearing.
Okay, no, I'm gonna say no because my opposition is similar to the I mean, reasons for opposition are similar to reasons for sex.
Okay, the reason, the oppositions are, explain that again, I'm sorry.
Yes, so the reason for my opposition for the motion is similar to the reason why I requested to set aside the orders. So, because there's no paternity testing, so there was never one.
Mm-hmm.
So, I mean, I don't understand how an order can be enforced for a child to go somewhere if there's no
Confirmation
DNA
of
testing.
of paternity.
Yeah.
All right, and I'm sorry, because I know this case is new to me, so you're gonna have to help me out a little bit. Is he on the birth certificate?
He is, yes.
Okay, so that's the confirmation that he's father. Now, the question becomes, I mean, is there opposition to a paternity test?
No, she's gonna pay for it.
Yeah. You want to pay for a paternity test? I can order a paternity test. I mean, that'll solve everybody's issue. Then we won't have to go through this. I mean, we can order a paternity test, and then that way, if he comes back the father, then we can proceed forward and deal with whatever custodial issues exist.
I'm not gonna pay for any.
Well, you're the one. Okay, so here's the deal. If you're the one that's saying he may not be the dad, so it just the same as if someone comes in here and says, "Hey, I think the other side's on drugs," or "I think."
I just signed some papers and paid some money. I wasn't even in the same room with him. I wasn't even in the same county.
The other side has some alcohol problem. Hey, you want them tested? We can have you pay for the test and send them down. So if you want his paternity tested, I'll absolutely order the test, and then you pay for it. If in fact he's not the dad, then I can always retax the cost of that and order him to reimburse you. But he believes he's dad, correct?
Yes.
Okay. So, I mean, I can send you down for one. That's not a problem. But you have to pay for it. It needs to be paid for. I'm not sure how much
There's
they
no-
cost. Do you know how much they cost? Does it say on the paperwork?
$60 per person, $90 per child, minimum of 180.
Yeah. So, I mean, if it's worth it to you to determine whether he's dad, then that's a small price to pay. I guess if you think that he's not.
Right. Is there any way you can order he pay his fees and I pay mine and my child's fees?
You mean like his $60? Why don't you want to pay for it?
I mean, I'm working 21 hours per week part-time, taking care of my child by myself full-time. I can't pay, 200 and something. I can't pay.
That's 180, right? 120. Well, it's actually it would be more than that. It would be 90. Let me read that again. Sorry. I
It's
don't usually
like
pay for.
210.
So $60 per person, mother, child, alleged father. Oh,
Yeah.
right. It's 180. Minimum fees 180.
Well, it's 60. Well, who gets the test done? It's just the father and baby?
Well, it's typically mother, child, and alleged father.
that's
So that way they can establish the baseline for everybody's DNA.
Your Honor, I think I can save the court and everybody some time. This case was filed last summer.
I know.
This issue's waived.
Your Honor, I'm gonna object.
Hold on. Look,
Damn it. Maiko, I need a paternity test for my 3 kids. I just want you to just take care of it, pay for it, send me the results just to make sure you're not the father. Boy, if you are, you owe me a lot of money in hair dye.
look. But if you have, I'm trying to solve a problem here,
I know.
okay? Because if you have the problem and it's an ongoing problem, there's no sense in not just going forward and doing that. From my perspective, it'll solve all of your issues in terms of that particular claim, right?
Fine.
So, hold on one second. I'm going to look at everybody's financials.
And also, may I speak, Your Honor?
Sure.
In terms of the plaintiff's financial disclosure form, he's only ever filed one. The previous judge ordered numerous times that they file an updated one. There's no
I am
tax
too.
returns, bank statements, or even pay stubs.
It's
to
supposed to be
prove-
three pay stubs,
Right, to
yeah.
prove that anything's true, there's nothing on file for the plaintiff. So
Mhm.
he's just put down a bunch of numbers on a piece of paper, you know. So, and I've been trying to challenge that with the previous judge, but she wouldn't hear it.
Our client is a professional poker player. He doesn't get pay stubs. And
Right.
he's provided ample financial information.
Your Honor,
at
I'm gonna
this
object
point.
Hold on.
to that.
Okay, so let me explain something. Everything in here is not evidentiary, it's offers of proof. So there's no objecting, it doesn't stop it from coming into me at this point. Procedure is, it's just argument. So you're making your argument, he's making his argument. I'm gonna allow you each to make your arguments, and I'll hear from both of you. I understand your position.
Finally, thank you, Kelly. I'm making them move out right now. Yep, pack it up. Get out, guys.
You know, he's going to have to ultimately explain to me when it comes down to the money issues how he earns his money. And I'll determine his credibility based upon, you know, all the facts in the case. But I'm just looking at his financial disclosure form here. Hold on one second. Okay, so, I mean, obviously then tax returns would be the better bet, right? Maybe the first couple of pages of the tax return to show what exactly his income is, what he's claiming as his income.
Absolutely.
And
I mean,
bank
it's not the
statements.
perfect, I mean, hold on one second. I know that, you know, he's obviously got to claim what he earns, and how he does that or how he calculates that remains to be seen, but
She can't complain about that. She's a server. She doesn't claim all of her tips.
if it becomes an evidentiary issue where we actually take it all the way to trial, I'll hear from him and whoever else may be able to confirm what his income is. In the meantime, if I can see some tax returns, that would be helpful, very helpful. So are you going to update then the financial disclosure form, Mr. Lytle?
Yes,
The
of
last
course,
one I
as soon
think I
as his
have
taxes are
here.
done for the-
Pardon me?
As soon as his taxes are done for last year, we'll update the court on that.
Does he anticipate that they'll be finished by the April date?
Yes.
Okay. All right, so that's helpful. So then if he files them by April 15th, can you have that submitted to me by, let's say, April 20th? At least the first two
Hi,
pages,
love.
redact the social?
Yes, sir.
Because the first two pages will give me the offset, you know, the expenses or the write-offs and the actual income that he claims for tax purposes.
Absolutely, Your Honor.
Okay. And then, Mom, look at yours. Hold on 1 second. Stick with me. I have a more recent one from Mom. Income's low. Check his. Okay, so I'm gonna say yes. And here's what I'm gonna, hold on 1 second. So she asked for his portion to be paid. You'll pay your portion and the child's portion? Okay. Because the way it looks to me right now is that there's going to be a child support obligation based upon the differences in their income. So if he pays his share and she's wrong, let's just say, then I can offset that against his child support.
Perfect.
Okay? So you'll pay your share and the child's share, and Dad will pay his share. And let's, I have the referral here. Hold on 1 second. I'll sign off on this. Let's pick a return date. How quickly do you think that you can get down there to do the testing?
580 days.
You can go today. Or-
Okay, that'd be great. You, Mom?
Probably not. I work later.
Okay, but how quickly can you get that?
I'm gonna say Monday.
Okay, perfect. So I'm going to say to schedule the specimen within the next 7 days. That way everybody has a window.
She ain't gonna
return
do
court
it.
Date. Give me,
She's not going to do it.
let's look at 30 days, and I hope that we get it back within 30 days, but we may or may not. And
I
then
just
we'll
want to
talk
clarify,
about.
Your Honor, are we deferring a decision on the pickup order until this paternity
No.
test comes back?
No.
Okay, all right.
Because he's already on the birth certificate.
Yeah, okay.
So,
I just wanna make
from
sure.
my perspective, he's on the birth certificate. That means it was acknowledged that he was dad. Now, if we ultimately determine he's not dad,
Sure.
then we can deal with that, right?
Of course.
But because then the question becomes, is there some kind of equitable scenario? Is he dad? Is the child? Will it matter? You know, is it in the child's best interest to deem him dad anyway? But we'll do a return date.
April 23rd at 11 a.m.
April 23rd, 11 a.m.
No, they're going to do a paternity test to see if he's the father. And the way she decided was the father has to pay for his part of the paternity test. The mother has to pay for the child. And if the mother is wrong, then the child support will reflect the father's payment. So the father will get his money back from the mother.
Court's indulgence, that may be Passover. but let me
Okay.
just double check.
If it's not convenient, I'll move it.
That is indeed Passover.
Okay. When is it over?
It ends on the 27th.
Okay, so
of
we want to
April.
do the 30th then? We'll just move it out a week. You'll know the results. If I get them in,
Right.
I'll let everyone know that they're in, and you can review them in my chambers.
And we'll
So-
do 10:30 on the 30th.
So it'll be the 30th. All right, at 10:30. Okay, so Mom, just so you know, if the results come in, my office will contact you and they'll let you know. Same with your office. Your attorney will get notification. You can review the results there. And go from there. Okay, so let me give you that. Let me give you the directions to where to go. All right, so let me hear the rest of the motions that were filed. So you're saying then you don't want the motion to set aside to go back down to Judge Marquis, that you're just withdrawing the motion to set aside and you want me to hear the actual case on the merits?
Right.
Okay. All right, so then we'll just take the motion to set aside the order off calendar. So if Mom's vacating that, and then I'll proceed on the other requests, okay? All right, very good. So Dad has a motion for pickup order. There was one filed that was basically held in abeyance until the chief judge made a determination on Judge Marquis. That basically she denied Mom's request to disqualify her, but then Judge Marquis was reassigned to a different department. So this case got assigned to Judge Ochoa, then there's a peremptory challenge, and so now it's here. Okay, so I'll allow counsel to make his argument, and then Mom will let you make your response, okay?
I just want to start by saying, in my 10 years of practice, this is the worst case of contempt I've ever seen. This is an absolute case of kidnapping by the mom. She was ordered on January 30th to produce the child. There was already a parenting plan in place that allowed for visitation. That parenting plan was modified to a joint custodial schedule, on a 2-2-3 schedule.
Right.
On the 30th of January.
Understood.
That visitation was to begin that afternoon.
Uh-huh.
And not only did she not produce the child for the visitation, but then her father, who I believe was present in the courtroom, went and filed a frivolous TPO, which was just denied about a week ago. It was
Was it
dissolved, actually,
Okay.
because it was entirely baseless. He was there that day
to exercise his visitation. It was 45 minutes after we left the courthouse.
Right.
And mom was nowhere to be found, nor was the child. He has not seen this child since January 28th. That is an unacceptable situation. We've done everything we could to make sure this child is safe. And
And he's taken the classes that were ordered, correct?
he's taken those classes. He's done everything he was asked to do.
Okay.
This has been almost 2 months now of absolutely no contact with this child. That is an unacceptable situation. Mom is in contempt. Mom has kidnapped this child, is hiding this child. Her whole family is in on the deal. And it cannot continue. He needs to get this child today. This pickup order needs to be signed before we leave the courthouse today. I don't know, like I said, I've never seen anything like this in my life. I really haven't. This is beyond the pale. And there's been motions to disqualify the judge. There's been all kinds of, the TPO filing by her father. There's been all kinds of procedural machinations to try to prevent this father from seeing his child for 2 months. It's unacceptable. I need the pickup order today. I don't know what else I can
Do you have an
add.
order with you? I know
I
that you
do.
submitted some orders.
I do.
but-
I have a revised version of the pickup order.
Okay, well, I'll take a look at that. And let me hear from Mom on this situation.
Okay, so since you're new to the case, I'm sure you've gone and you've read
I've looked at the
everything, yeah,
the
looked
record.
at everything that we previous. So I'd like to start with the background.
Okay.
So the relationship that the plaintiff and I had only lasted a period of 6 months. After I found out that I was expecting, I really didn't want to remain in the relationship, but I decided to stay to see what type of person that the plaintiff was, right? So in the period of 6 months that I stayed, I endured a lot of stress. During my short stay with the plaintiff, I found that he was extremely lazy, did not have a job, did not know how to do anything for himself, abused alcohol and drugs, and of course did not care for anyone but himself. So each time that I confronted him about getting a job, he would give me the same immature response that playing poker was a real job and that he would never get a job because he did not believe in working. So he'd sleep all day and then go out and get wasted all night at the bar, including abusing marijuana and cocaine with his friends. He didn't know how to take care of himself, including cleaning up his own space. Now, alongside with that, he didn't care for other people. At the 6 months that I stayed at his house, food was always an issue. I was not working during the beginning of my pregnancy, and I had to depend on him to provide food in the house. He never wanted to go grocery shopping, and I knew it had nothing to do with money because he had no problem feeding his other addictions, alcohol, drugs, gambling. And then whenever I would have an issue, I would call up my parents and tell them what was going on, and they would talk to him, but nothing would change. So there came a time in December when I was just fed up with everything. After the 6 months of pretty much being alone and not having enough to eat, I was, pregnant. I decided the best thing to do for myself and my unborn child was to make an urgent move back home with my parents. And so at 6 months, I drove across the country to come back to Las Vegas. And when I was back home, I started my spring semester of college, went back to work to prepare for my baby. And then a couple of months later, the plaintiff came to Las Vegas, promising he was different. His aunt started paying for an apartment for us to stay in March. But I remained at home with my family. The plaintiff
Nan, that says it all. That says it all right there.
started going downhill. His gambling got worse, and he would lie and drive. He would lie that he was driving for Lyft and Uber, but never, I really didn't even know what was going on there. And then I was on the lease for the apartment, and I found out that he wasn't paying for any of it. Simply logging in and seeing, how payments are being made for it. His aunt was paying for everything, all the rent. So the plaintiff never actually bought a single thing for the baby, despite me being very pregnant. I was going to school full time, and I was working, at least 20 hours a week, and he was just doing nothing in his apartment. Mm-hmm. And so I was gifted 2 baby showers by my family and my church, and the plaintiff never contributed in any way towards anything for the baby. Didn't even care, didn't even ask. And so a week before my due date, I stopped going to school and I worked it out with my professor so that after I had my baby, I could go in and take finals. I also stopped working so that I could rest before the baby was born. He was born on April 25th, and then after I was discharged from the hospital, I went home to be with my parents because I didn't feel comfortable being a new mom and being alone with the plaintiff because his head was not in the right place at all. I did, however, open the door for him to come and see the baby whenever he wanted to. The plaintiff would often not show up, and he would give me immature excuses that he either fell asleep, wanted to sleep, or had friends in town or wanted to go out. And I'm sure I did submit evidence, some text messages previous to that, of him talking about going out even after the baby was born, and I'm over here taking care of my baby by myself. So when the baby was circumcised, the doctor gave me instruction to give him small doses of
Do mine,
Tylenol
too.
to keep his fever down. And on that day, when I asked the plaintiff to buy the baby Tylenol, just a simple Tylenol, he refused and complained because he didn't want to drive from Centennial, where the doctor's office was, to North Las Vegas, where I was living with my parents. So because I didn't have any money, my parents volunteered to buy it for the baby, and they did. It's just Tylenol. So that day, the plaintiff never even came to see the baby to make sure he was okay or anything. I felt bad for my baby and obviously upset that his dad did not show any care or anything by his actions. He put other things before him. So following this time period, the plaintiff began to complain about how he had gotten an apartment and me and the baby did not want to stay with him. He would often threaten to go back to Wisconsin where he had his home unoccupied. Now, on May 20th, I took the baby to spend an overnight at the apartment just to see, how things would be if I was to go and actually stay over there. So that night, that's when I caught the plaintiff stuffing a blanket in the baby's mouth. When I confronted him about it, he said that he was doing it because the baby would not stop crying and I wouldn't give him a pacifier. Now, as a mother who was breastfeeding, at the time I still am breastfeeding too, I found no use in using a pacifier because when my baby cries, that would let me know either he was hungry, he needed to be changed, or hungry, tired, or needed to be changed.
And how old was your baby at that time?
Less than 3 weeks.
So he's almost a year old now, right?
Yeah, now he's 11 months. So that night, we had written down a schedule where we were supposed to have the baby. The plaintiff refused the two-hour schedule, 2 hours on, 2 hours off, because
She doesn't specifically say it, but she asked the father to take a paternity test because she's not sure he's the real father.
he insisted that he needed 6 hours to sleep. And so, you know what? I said, okay, we went with 6 hours, and I stayed up with the baby all night. Now,
That was a yes. Use both of those words.
come the morning, May 21st, around 10 a.m., it was time for him to have the baby so that I could have a chance to eat and shower. And the plaintiff started causing a scene. He became irritated and started saying that the schedule is, a stupid idea and that he didn't get enough sleep. Mind you, I was up with the baby all by myself. And so he didn't want to take the baby or even wake up. So when I left the baby responsibility on him and walked away to the bathroom, I heard some movement in the kitchen, and I'm on my toes as a new mom. What's going on? Where is my baby? What's happening? So when I rushed out, I saw that the plaintiff was going into the guest bedroom balcony. The guest bedroom had a balcony on it. And so I checked to see that the baby was there, and then I recorded the plaintiff jumping off the balcony from the second floor, and I have video footage of this, mind you. But I was really concerned. I checked my baby was there, I recorded this, and then he was literally physically running away from the baby. So normally I would have just, gone back home to where my parents were. But when I called them up, they told me, he had spent all this time complaining about the baby's not here, this and that, and I drove all the way over there with the baby across town for me to just, go back like that. So I decided I was going to stay in the apartment. So around noon, that's when the plaintiff came back to the apartment with police officers. And the police officers informed me that he had wanted me and the baby to be removed from the apartment. They told me that they couldn't do that, and that that's when they also did ask me if he was under the influence of anything because he was acting paranoid and stuff. And I told them, I know that I don't know what's happened between 10 a.m. and noon, like these 2 hours. He could have gone and done something, I really don't know. So for my safety, the officers were standing by. And so the plaintiff voluntarily decided to take a suitcase and pack a bag and leave, voluntarily. He said that he didn't want to be at the apartment and that he was going to leave. Fine. So the officers stood by and they watched him as he packed his stuff and left the apartment. So then later on that day, let's say around 3 hours afterwards, around 3, the plaintiff came back to the apartment, even though he had, caused all this scene, packed his bag and left with 3 of his big friends. And I believe I submitted my police report that I found there. I also do have footage of those people too. That he brought to the apartment, like wandering around the apartment. And so he came in with 3 of his big friends to intimidate me, but thank God my mom and my sister were there. And, they were gonna just stay there. I don't know what they were gonna do. There were really bad intentions there. So then when my mom told my sister to call the police, that's when everybody rushed out of the apartment. We never did actually call the police, but we did record everything, and they were there. And so afterwards, my mom texted the plaintiff her text was, why would you bring 3 big men to intimidate my daughter and a small baby? And the plaintiff actually replied, because you don't listen. So that obviously meant that he had some bad intentions, that he would have done something bad to me had no one been there. Now, between May and August, the plaintiff would randomly show up a few times at the apartment because he still had a key to it. I mean, he was on lease, he still had the key. And neither of us were paying for it. It was still his aunt. And so he never sent anything for the baby, never sent to me, never asked if the baby needed diapers or anything like that, never offered anything, never asked if the baby was okay.
I have a question.
Yes, ma'am.
So, are you object to him having, I know that you've opposed like the requests for contact, custody, what have you, visitation, and it's been slowly increased over time. The court ordered some initial contact and then expanded that, ordered some classes and what have you to address your concerns is the way I perceive it. Sometimes people don't always act the way they should right off the bat. Maybe they don't do things the way you think they should do them in terms of how you parent, in terms of how much attention they pay, maybe in terms of, were they really that interested? There are a lot of reasons why people do the things that they do. But now I have a dad here who says, hey, I want to be involved. And the judge already made the determination that he should jump through XYZ hoops and entered orders. And so I guess my question is, at this juncture, what do you think should happen? Because we're going to have a trial, obviously, but I'm stuck with orders that are in the case already, so I have to enforce those orders because they're orders. And I'll hear the trial, and you can tell me all of this and why it is that you think that the permanent order should be something different than the temporary orders. But I have temporary orders that need to be followed, and at this point, he'll either demonstrate I'm all in, I want to be a good dad, or I'm not capable and here's the child back. I need your help, I can't do this, I can't do these dates and times or whatever. But since all of that, he's actually demonstrated he wants to be involved. So what is your position on that?
Okay, Your Honor. So since that, the court when we went to court in August right here,
Mhm.
the judge ordered that the plaintiff start parenting classes before any visitation was to start.
Mm-hmm.
So, and then after he completed the parenting classes, I was supposed to receive a certificate to make sure that he actually went, right? And so we went back to court, and his attorney asked the judge if he can start the start visitation while he was taking the parenting classes. The judge, I don't know why, ordered that it was okay despite his history of endangering the baby, you know, stuffing the blanket in his mouth. And he really, I mean, has no basis in terms of like knowing anything about babies or even, you know, trying to make that type of effort. He's an only child, grew up in the only child in his family, no siblings, no cousins, nothing like that.
Well, they don't
And
give
so-
anybody a handbook when they come out of the hospital
Right.
for a baby, right? So nobody really, for first baby, nobody really knows how to handle
Right.
a first baby. But what's the story on this stuffing the blanket? I mean, obviously that's not an appropriate thing to do. Clearly,
It's not, and Your Honor, these allegations, again, this case was filed last, I think, July.
I understand.
These
I'm hearing.
allegations have all been raised, they've been vetted.
I
we-
understand.
we received
I'm
evidence.
telling her that. Look, I get it.
There was
I'm
no
just. I'm
stuffing.
allowing. Hold on. Okay, that's what I wanted to ask you. So he opposes. He denies the allegation, right?
Absolutely.
Okay, so ultimately, I'm going to end up hearing this in a trial. And in the meantime, like I said, I'm stuck with the orders that were entered.
Right.
And so they need to be followed. I know that there was a TPO issued that prevented any contact over at their house, but I haven't seen anything that shows that it was dissolved. Do you
I
have
just
anything?
got the order
Your
yesterday.
Honor, can I object
Hold
to
on,
that?
hold on,
Because,
hold
I
on.
mean, okay.
Hold on, because that's one of the reasons why I wasn't sure how that would be handled. Even if I issued a pickup order, I mean, he really can't go over there unless there's
That's
and
all
law
true,
enforcement-
Kelly.
I don't know how law
All
enforcement
true.
would look at that, whether they would enforce the TPO or whether they would enforce the pickup order. I wasn't sure what would happen there.
And also, I mean, I don't think that he should even be allowed to bring this up because it's third party, has nothing to do with
Well,
it.
you included him, you included the child and
it-
you
it
on the
wasn't
TPO.
included- The child wasn't included on the
Everybody was
Yeah,
included.
they
No, the child was not included on the TPO.
Are you sure?
I promise.
I thought I saw that the child was included, but you
No.
were included, right?
Yes, I was included
Okay,
because
so
I.
you have the child. You have the child, which means that he can't go near you or your
Right.
house. So I mean, it basically precluded him from having any contact with you.
Yeah, and it's based off
Right.
of his actions.
Well, I understand. I
Yeah.
understand. Look, I get that one was issued, but the point being, logistically, it precluded him from making any contact with you, which in essence prohibited him from getting the child, right? So it did the trick. Whatever you were trying to accomplish did the trick, right? So whoever accomplished it, dad or whoever. So let me hear
This
from you,
is-
Mr.
That's the,
What's
that's
that? You have to show her.
I'm sorry, that's the order granting his motion to dissolve the TPO.
Okay.
Your Honor, that does not have my name on it at all. It really doesn't.
No, it has her father's name.
Yeah.
I understand, but the
That's
TPO included you
Yes.
and your family members, everybody who was in the house. So that was why I was asking the question, because so it was dissolved
It was
and it
dissolved.
was filed.
I can also show you the order.
312.
It's in a separate email. I can show you the order denying his motion to extend the TPO, which was heard at the same time over in Justice Court.
Okay.
Okay, Your Honor, I
Yes,
also
ma'am.
have more, if I may speak, may I?
Well, we're not going to, just so you understand, I'm not going to relitigate or rehear everything, but so I want to hear from you as to why the child, because they filed a motion for pickup order, you opposed, and you said, your opposition says, well, I want a paternity test, number one, which I'm ordering, but he's already been deemed the father, more or less, by putting him on the birth certificate. There's a presumption. Obviously, the presumption can be rebutted. We can deal with that with the test. Hold on one second. I'm pulling up your opposition again. I just closed it out. I don't know why. Okay, so your opposition says...
I'd just like to know for the record, we were never served with an opposition. I haven't even seen
Okay,
the
well, I'll
stuff.
print it for you. Basically, it says, paternity test has not been conducted, given the plaintiff and I were never married. Evidence I submitted with great safety concerns need to be reviewed again as part of proper court procedure. But the court already
Why? Why was the paternity test not conducted? Was it dad's fault or mom's? It was mom's. But why? They didn't say.
vetted that, like counsel said. I mean, she's established a bunch of parameters for dad to lead up to this date where he has these custody orders. So initially it was just a couple of hours on certain days.
I'm sorry, may I respond?
I'm
Okay.
telling you what I saw what the court ordered.
Right.
It was initially a couple of hours on certain days. You were referred to mediation. You ultimately reached a partial agreement with joint legal custody. The timeshare that was originally ordered by the court was sort of agreed upon. There was a holiday schedule. Then dad was supposed to do his classes, and there was additional time added. And ultimately, after couple of hearings, the court ordered that you do the 2-2 or 2-5-5-2 or however you want to call it, the 2-2-3 split, where you would have 2 days and he would have 2 days, and then you would alternate the weekends.
Yeah, and the reason why she had ordered that was because there was just great conflict between the plaintiff and I. But also, I did provide...
Well, the reason why she ordered that is because she thought it was in the child's best interest to have contact with both of you.
Right, and all I was asking for the court was a supervised visitation. And so...
Well, that's a lot,
after, right,
because who supervises?
he doesn't have any family members or anyone that can make sure that the baby is safe at his apartment. I don't even know who goes in and out of that apartment. I don't know anything. And then
Well, he doesn't, okay, so.
and then so I wanted it to be at Donna's house because I read about it. I did a little research.
Okay,
I
but
read
the
about
court
that.
found that the visits that he originally did and the classes and what have you and the expansion of time was the appropriate thing to do.
Right, and then has the court ever received any certificate to say that he completed these classes? I don't even know.
The
if he
court made a finding in the last hearing, I don't have
Right,
them.
the court never have received certificates. I never received
Hold on.
certificates,
Let
and
me
then
look in the
okay.
file here to see if. Do you have any certificates? I don't know exactly if there's a certificate that was presented at the hearing because I didn't watch all the hearings.
I'm not certain if it was filed separately,
It wasn't filed at all.
Do you have?
but it was obtained and
Certificates?
presented.
No, it wasn't.
Do you have certificates?
You have this certificate,
Not on me, it's on my apartment.
but we have it.
I
What-
I've
completed the
seen it.
course.
Pardon me?
I completed the course, yeah.
But where's the certificate? After it's been ordered multiple times to be presented to the court and to me, never received it. And then
She was also ordered to take parenting classes. Did she get a certificate?
and on top of that too, there was a big safety concern during the first visitation schedule. So my baby would go Tuesdays and Thursdays for about 3 hours, 3.5 hours, and then Mondays, Wednesdays for about 9 hours.
Mm-hmm.
And so he openly stated on that Talking Parents app that he was going to starve the baby. He was starving my baby. My baby would be sent home like with no food. You know, I had to take him to the ER one time because he was unable to lift his head. When I took him there, they checked him. They said that the baby's empty. The baby's stomach is really empty. That I should go ahead and feed him. And so I breastfed him in the hospital. I went home and I fed him. And I had noticed patterns of this stuff. So I told the plaintiff, and I submitted these messages to the court too, where I told him, you need to feed the baby over and over again. You need to feed the baby. In mediation, the mediator,
How often does he eat now?
he eats all the time.
I'm sure,
Yeah.
growing boy. But
Right.
how often is his feeding pattern at this point?
He just eats whenever he has his little signals of when he's hungry, when he wants
And what are
to-
those?
He'll be fussy like a normal baby.
Mhm,
Or,
right.
I try to keep him on just a schedule, eating a breakfast, maybe a light snack or something during the day, and then dinner for sure. And then I breastfeed him throughout the day whenever he gets a little fussy or he's tired.
So are you feeding him regular foods now as well as?
Yeah, he eats
okay.
table foods. He has some of his baby foods as snacks too.
So thankfully at this point you don't have to worry about just breastfeeding, whether there's formula or no formula.
And even
which is
then,
good.
at the time, my baby was eating baby foods, and I told the plaintiff, you can give him baby foods. Give him baby foods. In mediation, I told him what type of baby foods to give to the baby, but he refuses to take any instruction from me, and honestly, I think that's a very vengeful character. If a mother is telling you,
Right, so.
feed my baby, and he openly doesn't want to buy the baby. It's a recurring theme, if you notice, food.
No way, I didn't choose this. Rebecca offered it. I had a pull Fozzie didn't like the poll because we're going with this, and we're going with this now. The baby is 11 months now.
You know, back when I was seeing
Oh,
him,
hell yeah.
he just didn't even care about eating. Now that he has now that he had the baby, he just didn't care about going to even buy baby food. And so when I would pick up my baby, I would breastfeed him, take him home, and feed him. The plaintiff openly admitted to starving the baby. And I told him before visitation even started that he needed to go to see a pediatrician if he was going to make the decision to give the baby formula because he was breastfed only.
But now we're at a point where we don't have to worry about that because now the child can eat regular food.
Right.
Right.
And the worry is he going to even feed him or
Well,
is he going to remain lazy?
Yes, he's going to feed him. He absolutely is going to feed him, or else he's not going to have him. But, okay, hold on. Just stick with me for a second. So I have this discussion with people all the time. Oftentimes, because especially when people break up and it's acrimonious and they don't get along and they're not really, I mean, a lot of times people come in here and disagree, but they still get along fairly well. They just don't disagree on maybe the terms of how their custody should look. And then there are cases like this one where it's just, there's conflict, right? Each of you often perceive that passing of information is somehow, quote, instruction, like she said, and therefore the other person just resists because they don't want to take instruction. And what I tell everybody is, forget your personal opinions about the other person, but provide that information because you're not providing it for your health. You're providing it because you know your baby and you know that your baby likes certain things, may dislike certain things, may need certain things because you've experienced it. And he may have a different opinion. He may think your child needs something different or wants something different, but it can't hurt to receive the information and at least consider it. If he doesn't follow it, it doesn't mean that he's not doing the right thing for the baby. It might mean he's doing something different. And you can't take offense to that either. But I think that what needs to happen is people need to be more open-minded and more concerned for what's in the child's best interest rather than take personal offense, right? So I just always give my encouragement that if someone
Me
relays
too.
information back and forth, that it's not to tell you don't know what you're doing. It's not to tell you you can't tell me what to do. It's really more about.
Fozzie fell asleep after the stream, and his biscuits and gravy were delivered. And then he woke up later and ate them.
Ensuring that you're doing a free exchange of information about what is best, what you think is best for your child, and to try and help the other parent. And he may have some information for you when he spends time with the child. Hey, look, as your child develops, things are going to change. Your child's going to have different needs. Your child's going to have different reactions to him than to you. But it doesn't mean that horrible things are happening. It just means your child is developing and changing, and each of you are experiencing different things because you're different people. You're different parents. You're never going to be the same parent. Ever, ever, ever. It won't ever happen.
Yes, Your Honor.
Right?
Can I speak? I'm sorry. I mean, all I'm trying to prove is that he really does not care about the baby. And while my baby is with him, there's no one to my baby can't sleep.
Why do you think that he's asking for custody then?
Because he doesn't want to pay child support.
Well, he's still going to.
Right, but even then,
So that doesn't make any sense to me.
I know,
When someone
but
comes in here knowing they're going to pay child support and they're still asked for time, when someone says, oh, they're just doing this because they don't want to pay child support, he's still going to end up paying. He makes more money than you
But
do.
no, even then, the previous judge ordered $67 of child support because of the financial disclosure form that he had submitted with
Well,
no.
that can be modified if
Right.
I get my information that I'm asking Mr. Lytle for.
Right.
So,
And then he can go ahead and file a peremptory challenge for a judge, pull out $450 from his pocket, but he thinks it's okay. He claim okay, so he's got a $1,500 rent. He's claiming like $1,800. He's got to pay for insurance, all the living expenses, and then he can pull out $450 from his pocket out of where? I mean,
I don't know, but we'll figure it out. We'll figure it out. So all these are interim orders.
Wait. Stop. Hold on. Time out. She stood in front of that judge and said, I want a paternity test. The judge said he's going to pay for his part. You're going to pay for your part. if he is the father, you're going to have to pay him back. He pulled out the money for the paternity test, took the paternity test, and now she's mad because he had money to take the paternity test that she wanted him to take. And she was adamant that she did not want to pay for it. I will not pay for it. No, I don't want to pay for it. No, I don't want to pay for it. Oh my God, he paid for that?
Just so you understand.
And then he's
And
sitting.
we'll,
he-
hold on,
sorry,
hold
yeah.
on, hold on. And we're gonna go to a trial. We'll get all that evidence and information. I can adjust those numbers. I can, if I find, oh, you know, he's making way far more money, just based upon the fact that he's paying all these bills. You know, if the bill payment and the claim of income don't match, then I can make some findings. But at the end of the day, you know as well as anybody that it costs more money to, instead of sending a check across the aisle to you to, here, you take care of the child, that costs more money to have the child in your care most of the time. So,
Of which I have no problem with.
well,
as
but
long
what
as
I'm
I
saying
make sure
is,
my
for
child's-
him to have the child in his care half the time, it's gonna cost him some money. He's gonna have to take care of that child, and as your child grows, it even gets more expensive. So,
And then he's sitting
all
there
right,
in
well,
court, Your
okay,
Honor,
so here's the
texting.
deal. We now have a dissolved TPO. We have a court order for visitation or custody. What,
I have the certificate.
Oh.
He just found it. That's what
Okay.
he was doing, not texting.
Okay.
He's trying to find you the certificate.
okay, so he
We
has the
haven't-
certificate
We haven't
then.
filed it yet, but
All right, so would you please get that filed? Pardon me?
I don't know what that is.
Well, I'll look at it. So, this is a certificate that Clark County Department of Family Services Parenting Project Certificate certifies Nicholas Ravello has successfully completed baby care December 1st, 2018. So, that was 15 hours parenting project as ordered by Judge Marquis. So, that's why the court expanded his time, because he completed that. So now we have, like I said, an order that needs to be followed. So I don't, whose weekend was it this weekend? It doesn't really matter because he hasn't had any contact, but whose was it to be this weekend? Was it
I
his?
have absolutely no idea.
I'd have to look at the schedule. Okay.
Your Honor, may I speak, please?
About what?
Shut up.
About the more information towards my opposition to their motion for pickup order.
Okay, but we have an order. You said you don't want to have Judge Marquis reconsider on the set aside. So your opposition basically says, look,
So if I have Judge
your
Mark-
opposition says, I want a paternity test, so I ordered that, okay? You also said I requested a continuance to respond to the motion. You've responded to the motions. You said you wanted time to consult with attorney. There's been plenty of time. That was back, a couple of months ago. Following your motion, there will also be a trial. Now the trial is going to be moved out, so you'll have plenty of time to prepare for that. And that the third-party protective order was hearsay and shouldn't be allowed, but it did affect the custodial arrangement. But other than that, that's all you've alleged in your opposition. So, from this court's perspective, we've
And then-
addressed all of that. So now, he needs to have his custodial time because it's ordered. It's
Right,
been
but,
ordered.
okay, so I didn't know that you aren't able to, change the order or anything like that when
You would have to come to me and file the appropriate motion or request showing me why that should subsequently be modified, with a basis, with a factual basis as to why it should be modified, okay?
And I mean, okay, so I didn't know that I was supposed to file a motion.
Okay, and I understand,
to
look, I understand you represent yourself, I get it, it's not the easiest thing, it's not even easy for lawyers, I get it. But you're required to know the rules, and I can't give you legal advice. I can only tell you that from what I have filed, there's nothing pending for me to modify the current orders. And the current orders stand.
And then
So listen, so current orders stand, and we will have a trial. We're gonna have a paternity test first, so that we determine for sure he's dad. Right now, he's presumed father, because he's on the birth certificate, so the presumption is already there. If in fact we have evidence that shows he's not father, then we'll deal with that. If in fact it comes back he is father, then we're going to have a trial. You're going to be able to present all your evidence, your witnesses, show me why it is that this custodial arrangement, the interim arrangement that was already ordered, shouldn't continue. He's going to try and show me why it should continue, or make his claim for custody, and then I'll make a final determination. In the meantime, you have to comply with the orders. So, and then you keep track of what goes on. He'll do the same. He'll make sure he'll keep track of his calendar, what he's doing with the child. You'll keep track of what you're seeing with the child. You'll both come in here and show me, hey, we complied with the orders, we followed the schedule, this is what I saw when the child was in my care, this is what I did with him, this is what he did with him, and we'll make a determination. Should it stay the same? Should it adjust? Should it be modified? Should you have primary? Should you have joint? We'll make that determination after an actual trial.
Okay, and
Okay.
then, am I able to then, say that I want the previous judge then to look at the, motion that I filed to set aside orders? Because
I
I
don't
didn't
understand
know,
what you're asking.
I didn't know that you aren't able to.
Let's see. Let's just guess how that'll go. If she goes back to oh, sugar. What's that other judge's name? It's like a Greek name. No, like Greek mythology. What is her name? I can't remember. She goes back to that last judge. Says, "Hey, can you modify this?" Oh, I wish we could see that.
To change the order.
I just told
or
you.
to modify. I mean,
But even
previous-
that, so the set aside is her to set aside the order. Then there would be no order, right? So then you would come here, and I guess I would hear the original motions again.
I won't do that.
But you just said you didn't want her to hear
But
the
I
set
didn't
aside.
know what that meant.
Do you, okay. So she's already told you this is what my order is. I mean, do you want me to send it back to her? I can do that.
Yeah, let's do that because I didn't know that. I didn't know.
In the meantime, you have orders to follow. You still have orders to follow, and there's nothing that stays the orders. Okay, the orders are in effect. They still need followed. I can send that motion to her to hear it, but in the event that she grants it, then we'll deal with that. But in the meantime, the orders still exist. So as much as you don't want to follow them because you don't like them, and I understand that, believe me, lots of people come in here and they don't like the orders. You're not alone. It still needs to be followed.
Okay. I have
Okay.
a question for you.
Yeah.
So, so I went ahead and filed my opposition to that motion.
I just told you what your opposition
Why-
says.
Right, and why would my opposition not be taken into
It
consideration?
is.
safety
I just
of the
considered
baby-
it.
Safety of the baby.
Well, that's not in your opposition. Your opposition says, like I just told you, that you wanted a paternity test, that you requested a continuance to respond to the motion filed before the judge. She suggested a certain amount of days. You accepted that. You filed this opposition, and that you have a trial that you're prepping for, and that the TPO shouldn't be considered. That's all your opposition says. So,
I mean,
look,
I thought
and I
that
understand you. Again, I've told you. I understand that you're an improper person. I understand that you're representing
I think you're right. I think it is Marquis. It is Marquis.
yourself, but you still are vested with the responsibility of knowing the rules. So at this juncture, I have to enforce the orders. Okay? So the orders are in effect. If you want me to send that motion to set aside back down for the limited purpose of Judge Marquis hearing the motion to set aside or to reconsider, I will do that. And she'll issue her
Beck,
order.
you're so smart.
And if in fact she sets aside the order, I will reset all the motions, and we'll come back here and we'll hear most of the motions on the interim orders, okay? But in the meantime, the interim orders still are in effect. Okay?
And even if my baby's safety is in, like, it's my
Mom,
baby's
another
safety.
judge already made the determination that your baby's safety was addressed. Parenting classes, short-term visits, longer expanded visits. And so at this juncture, I have orders I have to enforce. I don't have your signature on this, just so you know, counsel. I have to review this. I don't know what it says.
I'm
So-
happy to sign it, but
Would you sign it? And I understand
I
you
just-
want it right now, but, and I'm gonna have to take a look at it. I haven't read it. But would you please sign that, and then I can,
Oh, Victoria, you should have came 5 minutes earlier. I was worried about you because I haven't heard from you in a long time. So I called the police to come and check on you to make sure you're okay. Just put some coffee on or something for them. They're probably going to be there in about 3 minutes. Tell them I said hi.
Can always, where's your baby right now?
I just want to be really,
Home, okay.
And also, I don't want him to come to my house at all. I've asked the court many times if we can meet at a police station, because I just feel like it would be better and
You
safer.
could.
Yeah, I want that. The previous judge said that she didn't want, she claimed overexposure to law enforcement.
Well, I don't like it either, but, I mean, look, for everybody's, I mean, maybe even for his protection, that way,
There's a simple solution to this, Your Honor,
Yeah.
which is we can sign that pickup order and Metro can.
Metro will be there, I
They-
understand,
no,
but
no,
from,
I wanna be-
hold on. But Metro will only be there one time.
That's right.
And so the rest of their exchanges still need to occur. And so maybe we do them at the police station. And look, if she doesn't show up, then another pickup order would issue.
She is not going to follow your orders.
She-
Your Honor.
she may not.
I'm
She may
gonna
not.
object. This lawyer
She may not.
is
Hold
talking
on.
about me as
Hold
if
on.
he
Well,
knows
that's
me.
what they
He doesn't know
do.
me.
Victoria's the father.
That's what they do. They talk about, just like you talked about him, he's
Yeah, I
gonna
mean,
talk
but I'm
about
talking
you.
about plaintiff, not this
Well-
lawyer. I don't know him. You don't know me.
Well, that's his job. That's his job.
Doesn't know me.
If you had a job, or if you had a lawyer, his job would be to talk about the plaintiff. That's what they do.
If you had a job,
I know,
She
it
had a
doesn't,
lawyer
I know
for a
it's no
month ago,
fun. I
2
get
months
it.
ago.
This process is not appealing. I get it. And it doesn't feel good to have someone saying things about you. I understand all of that. But that's what his job is. He's an advocate for his client. And he's trying to present to me what he thinks will happen and what your behavior would be. Just like you're telling me what his behavior you think it will be. So, okay. So I'm going to read your order, and then I'll determine whether this one is appropriate to sign. But Mom, I'm going to grant his request for a pickup order because he needs to have his time with his child. It's ordered, you need to follow it. And then whatever the exchanges are from here forward, that you need to follow Judge Marquis' order. If in fact you don't follow it
Oh
and
my
you request
God.
another pickup order,
what are you wearing?
it just doesn't bode well for you if you just don't comply with the orders.
Okay.
In the meantime, I'm going to send the motion to set aside back to Judge Marquis for her to evaluate it. And we'll either have her grant it, and then we'll deal with your interim motions again, or we'll deny her. She'll deny it, and we'll stick with what we have until further order of the court.
And then in the meantime, am I allowed to file the motion to modify the?
You're allowed to do whatever is appropriate under the rules. So, hold on one second. Let's talk about trial dates. How much time does everyone need? Mom, do you have any plans to get a counsel? Do you plan to represent yourself? Is there discovery that's been exchanged on any level? No? Yes?
There hasn't been discovery, and I'm to be perfectly candid, I'm getting multiple calls a week right now from experts who are putting themselves out there based on videos of previous hearings that have been posted.
Uh-huh.
And so we're going to need time to get expert
Okay, well, I mean,
testimony on
I'll give you
pathogenic
time, because
parenting.
look, I have a calendar, it it's not like you can come in tomorrow and have a trial.
Absolutely.
We have lots of cases on for trial. So, how much time does everyone need for discovery?
At this point, I need 6 months. I mean, to be honest, with all of these developments in the last 2 months, that's now sort of front and center in our case.
She's never going to give over this child. She's not going to do it. She's going to get arrested. The cops are going to have to be called. I know it. I don't know it because I didn't see ahead. But Victoria, keep getting ready. You don't have to come to the computer. You don't have to type anything. I just want you to know I might need a bodyguard somewhere in Texas because Fozzie just sent me a text with a lot of swear words in it. It's almost all swear words. Victoria, protect me.
So, at
Are
least
you going
at
to
least
hire an
3 months.
expert?
I am. I'm going to retain an expert.
All right. So here's what I'm going to do, and this is what I've been doing lately. Is I'm going to give you a 90-day pretrial conference to determine
fine.
whether there needs to be additional discovery.
Perfect.
And that'll be, at least for now, discovery close. And then if we need more discovery, you'll have to tell me why. But you're gonna need to disclose your experts pronto and make sure mom knows who that is and what have you. Follow the rules.
And Your Honor,
Mom, do you intend to get counsel?
That's the thing, is I would have to work and save up a lot.
Have you
of
gone
money.
to, has she had counsel before?
Yes.
I
Had counsel
have,
before,
yeah,
right?
but the thing is, I can't pay an attorney like that, you know, I'm working 21 hours a week.
Does she qualify for legal aid?
I don't
Have you
know.
tried?
I've never, I don't know.
Maybe you should try legal aid. You might qualify for that.
Okay, where is that?
I don't have like a card or anything for them. We have their info on,
It's
Google it.
lacsn.org
okay.
is their
hold on.
website.
Yeah,
That
I'll
would
look it
also
up.
be for the form for Ask a Lawyer, which is legal aid of settlement matter.
Well, yeah, but she, that just gives her one,
See, I'm a lady.
that just gives her one appointment. LA. Is it LACSN, is that what you said?
.org.
Yeah. Okay, so see if I can find you a phone number. Okay, Mom, 702
Mhm.
386 1070.
Okay, and this is.
Because that, you know, if you qualify under your financial circumstances, they provide pro bono lawyers.
Oh, okay. And
Okay.
this is what's this organization called?
Legal Aid Center of Southern Nevada.
Oh, okay.
Okay. All right. So I'm going to look at your order. I have another trial right after this, so it'll be probably in the noon hour. Unless you two can work out an exchange time, but otherwise the order will be granted. Trial dates, or actually pretrial dates is what
We talk about logistics of like
when they should do their exchanges and what
Yeah,
have you.
child today.
Well, the court made orders of times, right? So, do they want to do the exchanges at the police station for now? I mean, we can always adjust that.
I want them to be at the police. I don't want them to.
We can always adjust that in the future. But it may just, I mean, it's 7 a.m. Mondays to Wednesdays, Wednesdays to Fridays. Leave those times the same unless the parties want to change them.
That's
Talk
fine.
to me, people. Talk to me.
Yeah, that's fine Monday, but I don't want him to come to my house.
I want him to leave here and go get this job.
I understand
That's
that.
what I'm
I
looking
understand
for.
that you want him to leave. I'm just
So
not going to sign
just
an order.
wanted
I
to
don't know
where
what
to
it
send
says.
him. Yeah.
Well, okay, so again, after that, they have exchanges to follow, and it says 7 a.m. Monday to 7 a.m. Wednesday, and 7 a.m. Wednesday to 7 a.m. Friday. So, do you want to do that at the MLK
Yes.
Central Command?
That's fine.
Okay, perfect. That way, there's no squabble. Peace will be kept. And if we need to adjust that when we come back, we can always do that. We're going to have a return date on the paternity test. What was the date again?
April 30th?
April 30th at 10:30, right? And then
What time?
pretrial
I'm sorry. What
April
time?
30th at 10:30 is the return from the
Okay.
paternity test, okay?
Thank
And
you.
then on the pretrial conference, let's do a 90-day pretrial conference.
It's gonna be June 25th at 1:30.
Okay. And that should at least get us moving in the right direction, and I will review this order, and we will let you know when it's signed, because I need to make sure it reads properly, that I'm not signing something other than, I just need to read it.
Sure.
And I need to have it logged in and logged out,
Absolutely.
so there's a process.
What
So
time today should be?
don't call, we'll call you. Don't
Okay.
call us, we'll call you. How's that?
That's fine.
Yeah, so, and then Mom, just understand that if you want to work with him to come up with an exchange time, you can do that, but otherwise, I'm gonna sign this pickup order.
Monday,
but
it
you
says
could-
Monday, right?
Well, Monday is the exchange time for your regular schedule, but is that his day, are those his days, the Monday to Wednesday? Or are those her days? I'm sorry, I just don't have this digested. Those are her days, so Monday to Wednesday is her time. Wednesday to Friday is Dad's time.
It switches every week.
I'm gonna ask
No.
for.
stays the same.
I'm gonna ask for some makeup time.
I understand you
Your
are.
Honor.
I understand. You can, but that can always be compensated. Okay.
I understand.
Because it doesn't make sense that if one parent has the child for a lengthy period, that we do the same thing in the alternative. It's not good for the child.
I'm
So
not suggesting
I
that,
can
but I would
always.
say, let's give him a week.
No.
Let's give him until
I can
a week
always
from
hold
Monday.
on. I can always give him compensatory time in the long term.
I
okay?
understand that,
Um,
but
because
it's been 2 months.
I understand. I get it, but the court determined that 2 days, alternating weekends was the schedule. So this Monday to Wednesday is always mom's. Wednesday to Friday is always dad's, and then you alternate the weekend. So I'm going to order that this be dad's weekend.
Your Honor, can I request that it be my weekend? Because I gotta make sure I
No,
can.
because dad hasn't seen the child in 2
Right,
months.
but I'm also breastfeeding. I have to make sure that I can, see my baby go long periods without, because the longest that I'm away from him is 6 hours when I'm working, if anything.
you
So I
pump?
don't know how it's gonna be.
Do you
a whole
pump?
thing. I can't. I'm unable to pump.
Have you tried?
Yeah, I've tried.
Okay, well,
And I already talked to the court about that. I've gone to the breastfeeding consultants at WIC and everything. I've done all that.
Okay.
But I just don't pump now. So
Okay,
I just need to
okay.
make sure my baby can go at least a day without milk. Just to make sure he's okay.
well, you're not going to withhold the milk
No, but I want to see how. Start getting him adjusted, because if he goes now abruptly, he's gonna go.
but you told me that you feed him and then you may give
Yeah.
him some milk in
And I give
between.
him milk, yeah.
Okay, so
If-
dad would give him something, a supplement, probably some formula
But
then.
the thing is, the formula that he was previously giving him caused my baby to have allergic reactions. He still hasn't disclosed the type of formula he's giving the baby. And I don't know what's going to happen to my baby. Is he going to
I
end up in the emergency room again, I just want to make sure
Let's
that he
hope
can
not.
go at least a day without milk.
There's gonna come a time, and it's gonna be today, that he's gonna have to adjust, right? There's gonna be a day
he's
when he
only
goes
11
without
months.
because you're not gonna be there. So there's gonna be that first day. It's gonna happen. And now there's been 2 months that have passed where he's grown even more so from the last time Dad's seen him. So hopefully now he'll
But Your Honor, he's only 37 years old. He's too young.
adjust even that much easier because he's much older. He's almost a year.
Your Honor, he's 11 months.
Yeah, he's
And
almost a
then
year old.
As a breastfeeding mom, I have the right to exercise my right to breastfeed my
You're
baby.
still going to breastfeed. You'll
Right.
breastfeed when you have him.
Okay,
And
but-
if you can ultimately, maybe you can try to pump again and see if that works. I mean, I know that it's been a while, maybe since you've tried. Try and see if you can try again. Then you can turn over some milk to Dad.
Your Honor, I'm unable to. I try, but I don't produce enough. How am I gonna go?
I don't understand that.
Right,
So
how
so
am
you
I gonna go
produce
home
enough.
and pump milk for 3 days, a weekend day in one sitting? That's unrealistic. That's not the way pumping works.
We've all done it.
Okay.
We've all done it.
It's not. I'm gonna need some time to even try to pump enough milk for even one day.
Okay.
It's just not how it works.
All right. Do your best. That's all I can say. So I will take a look at this.
Thank you. Your Honor.
Make a determination as to whether I sign this one or tell you I need something else. And I'm going to let you go for today. But Mom, just be aware that Dad's going to start exercising his time. Okay?
Well,
Alright,
we
so I'm
won't
gonna
find
get off
out
the record.
today.
Do
I'm
we have a
sorry.
date for the oh, yeah.
Before we go off the
Yeah.
record, I just want to be really clear about, is my client's going to follow your orders. So I just want to be really clear about when the next exchange is
Well,
supposed to happen.
The next exchange is supposed to happen, if he gets the child this weekend,
Right.
on Monday morning. And then he's supposed to pick up again on Wednesday morning. I'm gonna think about that.
Can we at least
Yeah, I might have him.
can we at
It
least maybe
depends.
push the time
Yeah, I'll think about it.
back or
I'll think
something?
about it in terms of maybe this week what I do. Just let
Okay.
me take
All
a
right.
look at your order. I'm not
Absolutely.
just signing willy-nilly any order. I'm not
No,
saying that
I
your
know.
order
I know.
doesn't say what it's supposed to, but I have to review it. So, yeah. So I'm gonna let you go for today.
Okay.
And you'll hear from me on the paternity test results. Everybody needs to go down and do the paternity test as well.
Yeah.
So, and like I said, Mom, you'll pay for the 2 yourself and the child. Dad will pay for himself, and we'll go from there. All right?
I thank you, Your Honor.
An order from today. Do I have anything? I don't think I need an order from
So
today.
you can't talk to her, you have a legal consultant, and a licensed attorney.
Thank you.
Actually, you know what, Counsel? Would you do an order like with the dates in it and everything from today,
I can,
please?
absolutely.
Okay. All right. That's going to be my order at this point. So we'll let you go, and we'll see you back here in about a month. Okay. All right. Thank you.
Thank you.
Let it sit any longer. So especially.
Oh, I was so upset I forgot to unmute myself. I need to know. I need to know if she gave that child to him or not. I need to know. Beck, this is your fault. Don't tell me, but I need to know, but don't tell me. We're going to find out next time on These Are the Days of Our Lives. Chaos, I know. Oh, okay. This is automatically gonna go right into the OJ trial. No, I can't. I gotta do OJ. I gotta do OJ. It's a weekday. And yesterday's OJ was a disaster. So and a cliffhanger. I got some really good clips today of another judge in another courtroom that I guess I'll try to make videos of since we're doing this. But these are really good too. Alright. We're going to end this stream. I'm not going to play the outro today because it's going to flip right over into the OJ. And I'm scared if I play a 2-minute outro, everybody will just leave. So, if you want to see my outro, go back a couple of videos. Victoria, if you're still here, have the best day at work. Bye, guys. If you're still on, I'll see you in just a moment because it's all going to be redirected very, very soon. Thank you so much for coming out. I really, really appreciate it. See you soon, guys.